Exactly.
Oh my God.
You, that matters to you.
Yeah.
You want to take this?
Oh my gosh, I'm so sorry. We can take you home.
That'd be great.
Yeah. Go around like our house. Where are you in?
Dollar.
Oh, yeah, yeah. I know that everyone. I went to Lyman High School, and I'm like 2 blocks from the Pre-Orthodox Church.
Oh, right.
I don't know what rules up. His foot's not as long. Look at her.
No. No, I cannot.
Yeah.
Okay, well, we're here. Yeah, we're here. Yes. Yeah. So many former circuit county have both hands and the trailer. And Wallace. He was in,
So everyone knows that they're streaming live already?
Oh, great, thank you.
yeah, so many.
That's what I was thinking was being, but I got all those policy You do. You gotta go to just like. Oh.
Thank you so much.
Thank you.
You come on. You can get that trash taken away. This one here, it's a little walk.
Okay.
Just be aware.
But then we have to jump up for a
Just so that you know.
Thank you.
Yep. Good.
Thank you. How are you? Good. How are you? Good to see you. Good to see you. There you go. Good to see you.
Hey, good to see you again.
Lauren's in the rest. Yeah, I just read it. Great. They're still issues. Interesting. Right. Right. True.
Sneaky. That's where I'm from.
His father died. Yeah, he's in Greece right now. Died on Thursday. Yeah, he's a little young to have that happening, but that's why I'm here.
Yeah, I wasn't expecting it.
He was good. He was
Yeah,
good.
I had talked to him just last week. So.
And he was kind of right in the case.
Oh, so sad.
Stout, Judge presiding. All persons have business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated. Well, good morning to each and all of you. We are now in session for the 5th District Court of Appeal. As our esteemed marshal indicated, I am Adrian Soud, and I have the privilege of presiding this morning over the 2 oral arguments that are set for today. Let me first, if I may, introduce the 2 distinguished colleagues with whom I work. To my right is one of our more senior members of the court, Judge Rand Wallace. To my left is Judge Paige Kilbane, and it's a privilege to work with these 2 wonderful judges. If I can at this time, just ask everybody if you have a cell phone or other noise-making device, if you'd be kind enough to turn those off or place them in a silent mode so it doesn't disrupt the arguments this morning. Of course, we would be grateful for that. We have 2 cases set for oral argument. The first case is case 24-2975. It is DL versus Community-Based Care of Brevard, doing business as Brevard Family Partnership et al. We will, of course, reserve 20 minutes per side for oral argument. Appellant's counsel will have the opportunity to present a rebuttal. We typically reserve 5 minutes for that, but Mr. Gowdy, of course, if you prefer a different time, you can let us know how much time you wish to have for a rebuttal. With that understanding, Mr. Gowdy, as counsel for appellant, you are welcome to proceed, sir.
Good morning, may it please the court. Brian Gowdy of Creed and Gowdy on behalf of the appellant and plaintiff, DL. My client pled a negligence action against each of the 3 defendants. A negligence action, as we all know, has 4 elements: duty, breach, causation, and injury. Here, the 4th element, the injury, was a sexual battery inflicted on my client. Thus, this action fits comfortably within the text of the exception to the general statute of limitations as found in subsection 9 of section 9511 of the 2022 Florida statutes. As we say on page 18 of our brief, this provision can be broken into 4 parts. First, an action related to. Second, an act constituting a violation of section 794.011, which is a sexual battery. 3, a victim under the age of 18 at the time of the act. And finally, 4th, and the action must not be barred on or before July of 2010. My friends and I all agree that elements 2, 3, and 4 are satisfied.
And you say barred, time barred. Time
Right.
barred.
Time barred.
Yeah,
I
sure.
was trying to be brief to save
I
time. But yes, time barred. On element number 1, my friends and I agree that the interpretation of this phrase in the provision, an action related to a sexual battery, is a question that no Florida appellate court has addressed. And I hope that today my friends on the other side and I can give the court some guidance about how to write an opinion interpreting this language. I'd like to do that by rebutting the primary arguments in the 3 answer briefs. The first one is what I call the straw man argument that suggests that my client and I are advocating for a construction that will result in, quote, an unlimited number of causes to be brought at any time. You see other language in the LeBron briefs about wanting causes of action that are too tenuous or limitless, or words like this. They're littered throughout the answer brief, not the reply brief. And to support this argument, my friends on the other side tried out hypotheticals of very different facts than the ones pled in this case. Of course, this court must decide only this case, and I think the holding can be limited on the following principle: that in this case, the sexual battery is the predicate for the fourth element of the negligence cause of action. It will have to be proved at trial that a sexual battery occurred in this case and is the injury my client is seeking a claim for. If the sexual battery is the predicate of an element of a cause of action, at the very least, that action relates to a sexual battery. Indeed, I would suggest under that circumstance, the action is founded on a sexual battery, which is a more restrictive connecting term. But you don't have to get to that because the legislature here chose, as the Ham Court states, that the broader relate to. And in fact, I think the Florida Supreme Court's decision in Ham, which my friend in the Brevard brief cited, is the best illustration on how this court can rule on this case and leave for another day the hypotheticals that I'm happy to answer about.
Mr. Gowdy,
yes.
Question, and I mean, I'm going to kind of dumb it down here. Don't read anything into that other than from whom the question is coming.
Yes, sir.
That wording in the beginning of the statute, an action related to an act constituting a violation of, that seems like a lot of words to say in the event someone commits a violation of 794.011. Would you agree?
It's a lot of words. I don't follow the question.
No.
Like,
what would be the purpose behind, in your mind, an action related to an act constituting?
well, I think it's defining a criminal offense.
Well, isn't that what 794.011 is?
Right, it's a sexual battery.
So, yeah, so I guess you answered my question. Isn't that a lot of words to get to the point? If someone commits a violation of 794.011, right?
Right.
It says the same thing, correct?
Right.
Okay.
Yeah, but I don't think there's any dispute here between the parties about that part of the statute, that we've alleged a violation of 794.011.
Well, but the wording "an action related to," that is central to
Yes.
this argument, correct?
Right. So it doesn't have to be, the legislature could have said that it was, that the an action based solely on a sexual battery. I like to use the term sexual battery just because it's easier than saying all those words, an act constituting a violation of 794.011. And so you understand, every time I say sexual battery, I mean to say all those words.
I think you answered my question.
Right, right. So, but the key language I think that the parties are disputing here is the first four words, an action related to. And what that related to means, it doesn't have to be that you're suing someone for a sexual battery. Related to means, I mean, it's almost, that's with respect to or connected to or concerns a sexual battery. As the Ham case, explains, and it cites in turn Lamar from the U.S. Supreme Court, these words, respecting, with respect to, relate to, concerning, about, if you go to dictionaries, you'll see they each kind of ping pong back and forth, and they all mean the same thing. And what you'll see in the case law is the courts say that those are broad terms, and a narrower term would be an action founded on a sexual battery. And then I think an even narrower term would be an action for a sexual battery. And so the legislature didn't say an action for a sexual battery. It didn't say an action founded on a sexual battery. It said an action related to a sexual battery. And we believe this case is an easy case.
Well, in taking your interpretation of that, that is a broader interpretation than some of the other language that you have used, correct?
That I have used?
No,
or?
well, that you just used in your
Yes.
in responding. And,
Yes.
And even this language is broader than the wording that I used, which was in the event someone commits a crime that would constitute a violation of 794.011.
Right.
That's a very specific, a much more precise
Yes.
and specific wording than what we have here in the statute, correct?
Yes, I
Okay.
agree.
My-
Yes.
Okay.
There would have been lots of ways for the legislature to narrow it to be either just solely an action for sexual battery, which means you could only, the statute of limitations is extended only for the actual perpetrator of the crime, or that it could have used other limiting language. Instead, the legislature chose to use what the courts have recognized as broad language related to. And I think my point in bringing up founded on was simply to say that if we had some of that more limited language, so I don't think, if it said in the event of a sexual battery, I'm not sure my negligence action would fall under that. But if the statute had said an action founded on a sexual battery, I think this action would qualify. Now, there's some others in the hypotheticals, which whenever we get to that I don't think would. And I think you're going to, the courts will have to look at each action individually. But here it's in the heartland. I mean, it's an element of the cause of action. It is the injury. And if we don't prove that injury at trial, I would concede that not only do we lose on the elements of the cause of action, but we would be out on the statute of limitations. They say, well, this will open the door if there's a physical injury. No, it won't. If we just show a physical injury and not a sexual battery, we're out. And if we just show a mental injury and no sexual battery, we're out. We've got to show a sexual battery at trial. And if we do, it's related to the action. It's part of the action. And what I wanted to point out in the Ham case, there the issue was
I
whether...
believe your position is related to, in this instance, doesn't mean the actual perpetrator of the crime.
Right.
Related to would be such as the appellee who was the spouse.
Right, all three of them.
Right. So it's a broader. Your reading and you're arguing the statute is broader. It applies to people that didn't necessarily specifically perpetrate the crime, but
Yes.
people who were overseers and or administratively over the situation, or in this case, the placement of the person in the home, correct?
Yeah, I agree with all that. The one thing I just want to say is it's not defined in terms of persons, it's defined in terms of the action. And Black's Law Dictionary tells us action is an exercise of a claim before a judge. It also tells us it's a lawsuit. It tells us it's a judicial proceeding. And so the question isn't whether a particular person can be a defendant. The question is whether the action relates to the sexual battery.
Okay, so you mentioned hypothetical. In what hypothetical, what fact is missing in this fact scenario?
Right.
That would not encompass this situation as these appellees being related to this particular sexual battery?
What type of hypothetical?
What elements or what aspects of a hypothetical would absolve these particular appellees from any liability under this statute?
Yeah, so let me first say that I don't think you need to decide for all cases, but I will give you some hypotheticals that I think would be outside and some that would be borderline, and then I think ours is like in the heartland. So as far as would be outside, in one of the answer briefs, they bring up a fact pattern where a perpetrator commits a sexual battery on a minor in a hotel room. The perpetrator walks out of the hotel room, trips and falls, and sues the hotel for negligence, slip and fall action. In that action, that negligence action, none of the elements would involve the sexual battery. The hotel's breach of duty has nothing to do with the sexual battery. The duty has nothing to do with the sexual battery. Causation doesn't. The injury, none of those have to deal with sexual battery. And in fact, I would suggest that if someone were to actually bring that type of claim, they would probably get the sexual battery excluded under Rules 90.401, 402, 403. So to me, that cause of action that's in the answer brief is clearly outside the statute. It's not even, the sexual battery is not even relevant at trial, much less related to the action. It's not part of the elements. So I think like a closer case that you don't need to decide today, but is in the answer brief, is they bring up the hypothetical about a sexual battery victim goes and sees a physician and then later alleges the physician commits malpractice in treating the sexual battery, okay? And this could, I think, come in a lot of different forms, not only in making a medical judgment mistake, a breach of the medical standard of care. Under Section 39.201, a physician has a duty to report a sexual battery committed on a child. So, it could be there are lots of different fact patterns, but it could be the physician does negligent treatment of the sexual battery or fails to report to authorities. And all of those, I don't think the malpractice would meet the test I'm laying out here. Like, I don't think that the plaintiff would have to prove the sexual battery necessarily for any of the elements, because the injury would be what the physician inflicted after the sexual battery. But I think that case would be a really close call, because it'd be hard to say that if you sued, for example, the physician for a failure to report a sexual battery, that action didn't relate to a sexual battery. And if you were trying to say that, say, a mental health professional gave negligent care of the trauma from the sexual battery, that didn't relate to the sexual battery. So what I'm trying to tell you is that my test, it doesn't necessarily fit for every fact pattern, and I don't think you should feel compelled in your opinion to write for that. I think ours...
That'd be pretty hard to do, wouldn't it?
Be impossible. And as Justice Gorsuch just talked in some of his recent opinions, the common law courts decide a case at a time, and that's how the law builds. And this case, I think, though, is it's an easy one, honestly, because the injury is the sexual battery. It's a part of the element. And what my friends try to tell you in the briefs, more or less, they have a couple different arguments. Like, for example, on page 14 of the Devereaux brief, it says that the appellant does not allege that Devereaux knew or should have known that Mr. Jones would sexually abuse the children in the care. First of all, that's factually false. Go to paragraph 23E of the complaint. It says BFP and or Devereaux knew or should have known that Bobby Jones molested other children in his home. But putting to the side the factual misstatement, I would submit it's wrong, because this is littered throughout the briefs. Their focus is on, hey, our breach of duty didn't involve us committing a sexual battery, or us aiding and abetting a sexual battery, or us conspiring on a sexual battery. And then they even make merits arguments, which they're going to get to do, which is we didn't know or shouldn't have known. Those are all to the merits of the negligence action, and those all go to the elements of duty, breach, and causation.
And Mr. Gowdy, just quickly, I know your time is expiring here.
Yes, actually, I'm already into it.
But for talking about the pleading, we're at a motion to dismiss stage on two of these and a motion for summary judgment. So, and we're looking at statute of limitations. Does that matter? I mean, if we're getting into merits arguments, those shouldn't be made at the stage we're at. Is that correct?
Correct. And a lot of the briefs is that. And I see I'm way into my rebuttal time, so I guess I should be quiet and sit down.
All right, sir. Thank you very much. Counsel for the appellees, and if you would let me know, do you intend to divide your time amongst the three of you? Is one lawyer going to address everything? Let us know how you wish to proceed in that regard.
We should proceed by all three of us coming up, and as you have questions that were specific to our clients, we'd address them, and kind of answer the questions as we go.
All right, and that's fine. Is there going to be one counsel that addresses argument primarily except for a question that may or may not be asked, if there's a specific question to a specific party? Is there a lead lawyer handling the argument? That'll be you? All right, ma'am, you're welcome to proceed.
Mr. Gowdy's a lot taller than me. May it please the court, I'm Dorothy DiFiore. I represent Brevard. This is
My name is Lauren Boveck. May it please the court, I represent Barbara Jones.
Good morning, may it please the court. My name is Michael Piccolo, and I represent the appellee, the Denver Foundation, Inc.
We do feel that we fall into a slightly different category with Devereaux and Brevard being more of the administrative component and Miss Jones being in the home. So we thought that you might have questions that were more specific to her versus us, but the two of us are essentially in the same position, we feel. We agree with Mr. Gowdy that this is a first impression for you and that you are faced with the task of determining just how important it is that everybody that's ever been in contact with a sexual battery of a foster child should be brought before the court at any point in time. And we're unfortunate that it's about sexual battery and about the horrible things that happen to children at the hands of people. But what the plaintiff is suggesting is that related to is almost unlimited. You heard that the doctor who fails to report that a sexual battery might in fact be involved. There's actually not a significant difference between that hypothetical and what we're talking about here, because the allegation against us is that we failed, at least as to us, that we failed to pick up some red flags years ago that would have told us that Bobby Jones was going to have a sexual battery going on, and that's why we negligently licensed the home and placed DL there. And then there's we failed to ensure that the home was safe, which is essentially saying we failed to take action after we learned, because we knew or should have known as of June when it was first reported. And that's essentially the same thing as the physician who doesn't report the sexual battery. And so now you're beginning to drag in physicians, you're beginning to drag in all the people that ever have in touch with this child based on the fact that the injury is the sexual battery. The very important point that he made is that he believes that it's focused on the act and not the actor. And I think that in fact it turns it around, because the cause of action is against the actor. They expanded the liability for the actors who perpetrate these horrible acts against children. They did not say anyone related to that in all time. They use this phrase related, right? And we talk at length in our briefs about the interpretation of related to. There's the fourth district.
The related to aspect of this case involves these two appellees, Devereaux and Brevard, allowing the placement to take place and the monitoring of the placement, correct?
So I don't know that the monitoring of the placement is very well pled, but I think it might be inferred from some of the statements. If you look at the complaint in the paragraph 23 that he describes things that we knew or should have known, there is a discussion about the fact that Bobby Jones molested other children in the home. Now, again, remember the argument is we negligently placed her there, right? So that would have been a decision that was made before these allegations were raised in June of 2014. I am not talking about proof, I'm talking about allegations. So in the first paragraph of 23, we talk about numerous prior reports, criminal history, all these things that happened long before June of 2014. The only thing that seems to come after June of 2014 is the allegations of ongoing sexual acts, and the foster parents were aware Bobby Jones had molested other children. Again, there is no allegation that information was ever known to Devereaux or Brevard prior to the June 2014 discussion about sexual abuse. The sexual abuse, though, in June of 2014 was not Bobby Jones' sexual abuse. June of 2014, it was about child on child. It was actually about a DL doing something inappropriate. And that's what's in the complaint. I'm not looking at the facts. I'm not trying to get into the merits of this. I'm asking you to look at what they've pled. And what they've said is that in June of 2014, it was discovered that DL was doing something sexually inappropriate and that there was other child on child. Again, not anything to do with Bobby Jones until it came out later. So what we knew or should have known in 2014 is actually not really the basis for negligent licensing. If you look at the allegation against Brevard, and it's identical against Devereaux, in count 1, after going through what all of our duties are, they say BFP, that's us, negligently licensed Bobby Jones and Barbara and allowed DL to be placed. all of which occurred before June of 2014. So this is all about what we should have known before, and yet he has got no allegation that we knew or should have known about it before June of 2014. Now, if there is an inference to be drawn that after June of 2014 and before November of 2014, when DL was removed from the home, and it was that short, the allegation of child on child arose in June, she was removed, the home was closed by November, and that's what's in the complaint. There's additional information, but we're not going to get into that. And then it was a year later that there was discussion of Bobby Jones' sexual battery on her. And it is Bobby Jones' sexual battery that is the basis of this. He made that very clear. It's the sexual battery of Bobby Jones. It's why he's suing Miss Jones, right? So the allegations don't show that we knew or should have known at the time of the placement, or even up until June of 2014, that there was any sexual misconduct of any kind that would have said this relates to a sexual battery. It's only after June of 2014, through the limited window of November 2014, that there may have been some failure to monitor.
Are we into the merits at this point?
No,
I know
not.
I know you mentioned earlier about we're just asking you to look at the allegations, the complaint, et cetera.
That's what's in the complaint. So that's all. I don't know. I came into this case after the fact as the appellate attorney. I don't know what the actual facts are. I have that actually very easy. I can only go with what's in this complaint.
It seems to me the entirety of the case determines how the court is determined by how the court interprets related to.
It does. It absolutely
that seems
does.
to me to be, it's not a timeline of events, it's not what is in fact or what is alleged or in fact to be known or should have known. It is how do we interpret the phrase related to. You agree that's this case?
I absolutely do agree.
There's no dispute that the allegations are sufficient to alleged violation of 794.11. You agree with that? That's not
By Mr.
disputed.
Jones, correct.
Okay. So what I'm trying to wrap my arms around just a little bit, and I would welcome your response or anyone's response to Mr. Gowdy's argument of hypotheticals. It's always an interesting dynamic. Sometimes arguments can devolve to hypotheticals as to, well, this hypothetical situation would interact with this case in this particular way. It's difficult for courts to write a case, write an opinion anticipating every hypothetical. So
Agreed.
should we cast our gaze only upon the facts presented here and not be overly concerned with hypotheticals? How would you respond to his argument?
Well, actually, we think that this court can give guidance to the trial courts in Florida that are going to be addressing the foster care system in regard to sexual battery. Hopefully it won't be often, but we know it happens. And we believe that much like the tests we put out for the substantial relationship tests in a choice of law or the forum nonconvenience test, that we look for a direct and specific connection. When you look at the interpretation of related to that's come through, even in the Ham case, the court said, although the account stated claims could not fairly be said to be based on, under, or pursuant, there is nonetheless a clear and direct relationship between the credit contracts and the account stated. A clear and direct relationship. I think that is a standard that you could apply in every context. Does it require a case-by-case analysis? Yes, but the standard is still the same. The substantial relationship test for choice of law has the 4 criteria, and then you look at the facts of your case to see if it's there.
Do the facts as alleged in this case satisfy that test?
I do not believe they do. Because what they're saying is that any act whatsoever occurring prior to this sexual battery makes you related to. When you look at the statute and the evil it was designed to cure, I think we can all agree that related to is not necessarily the clearest language, and perhaps we can go outside of just 2 words, that we can look at what was it intended. We all know this came out of the church abuse scandal. And who did they want to get? They wanted to get the church, the Boy Scouts, whoever was actually complicit in enabling this abuse to continue. They went for vicarious liability. I wrote down some things that I thought you could look at in terms of maybe deciding if it was a direct. Is there vicarious liability on the part of the person you're suing for the direct action? That was the archdiocese. They employed the priests, they kept the priests in the school, they hired them, they trained them, they moved them around. Direct employer respondeat superior. absolutely spot on. Those people should be responsible for the acts of their agents and their employees. So we look at something along those lines, like a direct respondeat superior or vicarious liability.
But counsel, why would we rewrite the statute? Whether that was the legislative intent or not, it doesn't say substantial relationship. That's a defined term in the case law. I understand that. But relate to or related to is a much broader term, and that's what the statute uses. So how would we superimpose that, a substantial relationship test or any of these other tests that you're asking us to sort of grift on to the statute? Why would we do that? How do we have the ability to do that from our seats?
We're actually not asking you to graft anything into the term. We're asking you to provide guidance as to what related to means.
But why would it mean something different than what it says?
Because the broadness of that term makes it untenable. It makes it so broad that you've eliminated the purpose of statutes of limitation. You've opened up liability to the entire world, essentially. So if you look at the discussion of related to at the United States Supreme Court, at the 4th District Court of Appeal, at the 11th Circuit Court of Appeals, they all agree that the courts need to say related to is not the unlimited connection that could exist. They talk about how you basically eliminate the purpose of using that. It's supposed to be a somewhat of a term of limitation, and yet if you broadly construe it, then it doesn't even accomplish that at all. So the courts have specifically said that when looking at this specific term related to, there needs to be some sort of guidance as to how far does that go.
Well,
and that's all we're asking for.
But would not the guidance come from a fair reading of the language chosen deliberately by the legislature?
Well, we are all struggling today to find the guidance as to what related to means. So that's what the problem is. They use this term related to, for which there is very little jurisprudence, and they are expanding the liability potential far beyond what the situation out of which this change in the law arose, and now they've left us with this very broad, vague, ambiguous term related to.
So if you were in the legislature, since certainly hypotheticals have been presented, if you wanted to write the broadest statute possible, would you choose language different from what we have in front of us?
Well,
Can you think of anything more broad than related to?
I do believe that you can expand it with more connections. For example, I work with insurance companies, and when they want to exclude an assault and battery, they've made it arising out of, related to, connected with, and they go on, and they make it very clear that anything that mentions the word assault basically will not be covered. So there are ways to do that. Arising out of is also incredibly broad, and the courts have addressed that as well. So, but even arising out of requires a nexus.
Is it more broad than related to?
I'd have to look. I don't,
I mean,
because there's not much case law on related to. There's a lot of case law on arising out of, which makes it very, very broad. And so related to is not that much different from arising out of, I think, so.
Okay.
So you think your reading of the statute related to and this, and these facts applied to this law would limit it to only the perpetrator of the crime?
No, I do not. I believe it could relate to anyone who was responsible for him. Now, Ms. Jones does not think she was responsible, and she does not believe that there's an allegation of that, but we are not responsible. The fact the legislature has very specifically said that the lead agency is not responsible for any negligence on the part of their subcontractors. They've taken a great deal of trouble to make sure that in the foster care system, each party is only responsible for their own acts. All right? So we are not in a position to be vicariously responsible for the foster parent. We are only responsible for our acts, which is why they start alleging about our acts, which occurred well before this. And the accusation is that negligent credentialing back in 2006 should relate to an act of sexual battery in 2014. And I think that's where we lose the connection. As I said in my brief, it's about how many degrees of separation from the battery do we get. Every other case in which there's been this sexual battery situation, the claims have been directly against an employer. I don't think that's the only thing. So, for example, there are also, when there's an ability to control the actor, like the churches and the Boy Scouts, to some extent they had control even if they weren't vicariously liable for them. And I do think, obviously, if we had the ability to control Mr. Jones in the sense of we were his employer, we were directing the contract, et cetera, the only thing we had the ability to control was the licensing, right? And the information, according to the allegations of the complaint, was not there on our negligent licensing. And our negligent licensing is not negligent because of the sexual battery. Our negligence was allegedly because of something else. So we have been brought into this lawsuit because we failed to pick up on some things that might have made them not an ideal situation. But now we're going to be sucked in forever because, unbeknownst to us, somebody committed a sexual battery at the house. And it's just, that's where I think you get too far apart. Is it the teacher and the school board? Maybe. Is it the priest and the school and the archdiocese? Yes, that's who I think is involved here. Related to the actor, right? We're relating to the actor. The act of sexual battery has occurred. Who committed it? That's what the idea is, right? Who committed the battery, and then who relates to that person and how. And we actually didn't license Bobby Jones, by the way. We only licensed Barbara Jones. So he was in the home. And I don't think that's relevant, but it was alleged that we licensed him. So we think that if this court can set out some parameters of how far and tenuous can it be, because the courts have done that consistently with this phrase related to. The only case in Florida is the Ham case, which talks about a direct and substantial, clear and direct relationship between the cause of action and the actions of the party that you're after. To simply say anytime there's a sexual battery, anyone who's ever come in contact with this, who is connected in some tenuous way, should be sucked into the litigation forever and ever, is I think, an unreasonable interpretation of a statute that's not exactly clear and unambiguous. And when you have a clear and unambiguous statute, then you don't go outside, right? When you have some ambiguity, you can go outside the plain language and look at how do we guide the courts in interpreting that. I would like to give 3 minutes.
Your argument is related to is ambiguous.
I do think it is. And I do think that it's so broad that it requires assistance in discussing what it means. And then you look at the purpose of this statute. I would like to give my co-counsel an opportunity to discuss their perspectives on this. I don't want to hog the entire stage. And I don't know if you have questions for either of them from a perspective.
I do think that Ms. Jones' position deserves at least a moment in time, because obviously she has a different position than the actors who licensed and who supervise the licensing agency. But I still think that what the appellant is trying to do here is, as long as there is a sexual battery, everything that harkens back to that. So Ms. Jones is here because of her proximity. And I think the ambiguity of the statute is that it could be related to the action or related to the actor. And so either way, we're capturing these very broad actors. And what that does is it creates a policy atmosphere where for forever, Ms. Jones can be held liable for something that she had no control over, her husband. Whether we have control over our husbands or not is maybe an argument for another time, but that connection is tenuous. That connection is not as direct as if, like in the Catholic Church's scenario, if there was another priest who concealed, right? Then you don't have an employer-employee relationship. We don't have any employer-employee relationships in this case. But if they are participating or connected in a direct way, if there are facts that connect.
Is there a closer relationship than a spouse?
I mean, maybe a sibling or a child, but I think for these purposes, the connection has to be also to the action, to the sexual battery. And I think that goes into what is alleged in the complaint.
Sure, but if your argument is employer-employee type relationship and what information known to the employer related to conduct of an employee, how would that not with equal or more force apply to as alleged, a wife who knew or should have known of a husband's actions or tendencies, etc. I don't understand that distinction at all.
I think that the problem is that they have not, in the complaint, alleged sufficient connection to that. I think there are facts maybe that could present that scenario. But
So if sufficient facts are alleged in a complaint as it pertains to one spouse's knowledge in a given case, then that may sufficiently be related to for purposes of the statute. Is that what you're saying?
I'm saying that I could see a scenario where a spouse could be held liable for the acts of their husband.
So then your argument is more one of, is a factual-based argument, not a language-based argument.
Well, I think they're one and the same, Your Honor. I think you can't be related to without some facts that relate to the action, right? Otherwise, then it's just the sexual battery that relates everything. So as long as we have a sexual battery, everything, regardless of the facts, are related to the sexual battery. I feel like you have to have the confluence of both of those things. Otherwise, we're bringing in everybody, like the plaintiff's saying we're not. But I think their definition is almost like an ends to a means. Like, if you have the injury and the injury is sexual battery, then we've got a great long tail. And now it's forever.
All right, so let me do this. Marshall, if you would, we'll grant 2 minutes and a total of 2 minutes additional time for each side. It would be cumulatively for the appellees and then 2 minutes for Mr. Gowdy so that you all can conclude your argument.
And I think I'm going to pass to Mr. Piccolo since I've spoken enough.
And as my co-counsel set out originally, the position between Devereux and community-based care are very similar factually. One other thing I would bring up with respect to the statute itself, I not only think it's ambiguous, I think it's vague. I think we're trying to draw lines here in terms of where is the line for related to needs to be. Focus on knowledge, focus on action, as Judge Wallace brought up. It's an action related to an act constituting a violation. And that, related to is the crux of the argument, but I think constituting a violation of the act is also very important here as well. So I would just conclude with that.
And finally, I think that it's very significant that when you asked Mr. Gowdy for what case wouldn't fit, he could only come up with one hypothetical that was in our briefs, the trip and fall. He didn't really give you any other examples when it would not be related to a sexual battery, and I think that's exactly the problem here.
And we'd ask you to affirm.
Thank you all very much. Mr. Gowdy, with the additional time granted by the court, you have 5 minutes, 35 seconds.
Thank you, Your Honor. I could give you, if you gave me 20 minutes, I would give you a long list of hypotheticals. I'll just give you one more. Suppose that there's a non-payment under the contract between Brevard and Devereux, and there's a non-payment, and somehow Devereux didn't get their money. I don't think this statute of limitations extender would allow Devereux to have more time to sue Brevard for that, just because there was a sexual battery involved in the placement. So, and I could just start listing off hypotheticals, but we don't have time for that. And I think you're right. We need to decide this case. And what I did hear opposing counsel say at some point, well, first of all, I said we're all struggling. I'm not struggling. This is an easy case. It's in the heartland. I gave you a harder case, the doctor one. I didn't ask you to decide it. I just wanted to point out there'll be harder cases later. But the breach of contract I just mentioned is easy. The trip and fall is easy. This case is easy on the other side of the line. I also heard counsel at one point say the basis, maybe I misheard her, said the basis of the claim is a sexual battery. That ought to be the end of it. All these other arguments you heard, you would hear those exact same arguments if my client filed within 4 years of the sexual battery, which is the normal statute of limitations. Every single argument is about whether or not they knew or should have known. Those are the arguments you have under the common law of negligence. They're arguing about proximate cause. That's a negligence. We're just here. They're acting like, oh, we're going to get sucked in. Well, if my client had filed this action within 4 years, we would be litigating all these issues they're talking to you about. My friend mentioned the statute in Chapter 409.993. We're going to litigate about that later. They're going to claim, oh, we're not responsible. That's not before the court today. You just have to interpret 4 words. An action relating to. They've conceded there was a sexual battery. And then I heard my friend say, well, you asked a great question. How could you make it any broader? And my friend said, well, insurance companies use words like related to, arising, and she ran off a whole list. Please go read the dictionaries. Those words she all mentioned are in the dictionary definition. Please go read the Lamar case that's discussed in the Florida Supreme Court's Ham case. Lamar is a bankruptcy case. They talk about how these words all mean the same thing. She just told you that the legislature doesn't have to be like an insurance company and give an infinite list of synonyms. It doesn't have to give the whole list in the dictionary. But related to is synonymous with respect to, respecting, and these are the broadest terms possible. As far as Judge Kilbane, you're absolutely right. Judge Soud, and I think all 3 of you understand this. We look at the text to discern the meaning of the law. One date I'd like everyone to etch in their memory is August 25th, 2022. That's when the Florida Supreme Court decided Connage. And in Connage, the Florida Supreme Court made it very clear that we were receding from 30 to 40 years of precedent under Holly v. Auld. If you go back and you look through all their cases where they're citing, hey, we get to look at the ambiguity and then we get to look at the legislative history and we get to look at all this extraneous stuff, that's all flowing from Holly v. Auld. August 25th, 2022.
Intent's no longer the poll star.
I'm sorry?
Intent is no longer the poll star.
Exactly. And that's what all the cases in their brief are from. They're before August 25th, 2022. And Connage was a landmark case in the textualist here, and I still see even courts sometime citing cases from the Holly v. Auld line of cases. This court in Taylor and TG v. United has rejected the legislative history. I won't go through that. I do want to go through the Ham case because I actually think it's great for us. So there, the issue was whether an account-stated cause of action was, quote, with respect to the contract. That was the statutory language. With respect to, as I said, is synonymous to related to. And, it was 6-1 decision, but the court reasoned an essential element of an account-stated cause of action is proof of the existence of a business relationship between the parties. And then the court said, the business relationship here was predicated on the credit card contracts. That's page 49 of the reporter. I'm sorry, 949 of the reporter. And we have this, and so the court then came to the conclusion, even though the cause of action was not for a breach of contract, it was for account stated, they said that it was with respect to the contract. And we have the same thing here. An essential element of a negligence cause of action is proof of injury. And the injury here is predicated on the sexual battery. They even said it. Game over. Thank you.
Yes, sir. Thank you both. Thank you all very much for well-presented, well-prepared arguments. As we give council an opportunity to gather their belongings and next council to move in position, the next case for the court is Ford versus State of Florida 24-2120. All right, counsel for Mr. Ford, Mr. Greenlee, is it?
Yes, sir.
Good morning to you, sir. How much time would you like to reserve for rebuttal? Is 5 minutes acceptable?
5 minutes is acceptable.
All right, sir, you're welcome to proceed.
Good morning, Your Honors, and may it please the Court. My name is Andrew Greenlee, and I'm here on behalf of the appellant, Mr. James Ford. Your Honors, the question at the heart of this appeal is whether an individual may be prosecuted and convicted for human trafficking when there is, in fact, no human and there is no trafficking that actually took place. We know from the Yates case that even when the conduct at issue can fit within a broadly worded definitional term in a statute, it can nevertheless not cover the conduct at issue. The Yates case dealt with Sarbanes-Oxley law, which is a record-keeping statute. The gentleman, the defendant in that case, was a commercial fisherman who had disposed of a fish.
Right, but counsel, we're not talking about fish versus paper here. We're talking about a crime involving a child and traveling to the location to meet the child, and the child just happened to be a law enforcement agent instead of the child.
That's correct, Your Honor.
And attempted human trafficking, do you dispute that's a crime? That is a potential issue?
No, that's correct. The
Okay.
attempted human trafficking is a crime. Our contention...
So the fact that he didn't get to complete the act, that should absolve him of human trafficking?
No, Your Honor. No, that's not our position at all. We don't dispute that there is an attempted, you can attempt to commit human trafficking. Let's say, for instance, he had attempted to overbear an individual's will, a minor's will, and serve as, for lack of a better term, the purveyor of her services on behalf of other people. In the same way that we view, like, let's think about it, take a step back, drug trafficking, right? The people who are the drug traffickers are the people who smuggle the drugs, the high-level dealers. We don't prosecute the people who are low-level purchasers of drugs as drug traffickers. So, again, in the normal parlance
But they can be, in certain, depending on the facts, right?
If they're purchasing huge amounts, yes, the drug trafficking statute can apply to them. But low-level offenders who are purchasing minuscule amounts of drugs, we don't view them as traffickers. We don't treat them as traffickers. The law shouldn't treat them as traffickers. In much the same way, people who produce child pornography are treated differently under the law and more severely than people who have that contraband on their laptop, for instance. So again, these are distinctions that are germane to what's at issue here, because again, there is no evidence, and just to turn, because this is a case of statutory interpretation, to turn to the language of the statute, not only is the title of the statute human trafficking, which we know from Dubin and the aggravated identity theft that was at issue there, we look to the actual title of the statute, human trafficking. What's the first sentence say? The legislature finds that human trafficking is a form of modern-day slavery. And then that paragraph, which is important, it goes on, victims of human trafficking are young children, teenagers, and adults. So we know this applies to adults as well. Thousands of victims are trafficked annually across international borders. So the movement of people is what this case concerns. The actual trafficking of people. It goes on. Many of these victims are trafficked into this state. So look at how this verb traffic is used here. I mean, if you take, well, let me just continue on. Victims of human trafficking also include citizens of the United States and those persons trafficked domestically within the borders of the United States. So this statute primarily is concerned with taking people against their will and moving them from place to place, using them, exploiting them for, and again, just reading from the statute, the legislature finds that victims of human trafficking are subjected to force, fraud, or coercion for the purpose of sexual exploitation or forced labor. There's also a provision in the statute that deals with branding. You brand someone. That's an enhancer under the statute. So these are kind of the class of actions, the classes of conduct that are at issue in human trafficking. We wouldn't, I don't think anybody here in this courtroom would say that a person who goes, for instance, in allegations against Robert Kraft, who goes to a massage parlor and gets a massage that's inappropriate, has trafficked that individual. He's a consumer of the commercial sex trafficking. That is true, but he is not the trafficker. He is the one who is partaking in the trafficking. And that there are crimes that cover this type of conduct. In fact, what he was initially charged with, traveling to meet a minor. You know what? We don't dispute that the evidence was sufficient to convict him of that crime. But the crime of human trafficking, that's altogether a different kind of class of behavior that the statute is getting at. And we don't believe that he was guilty of that. And so again, we know from...
That's not what the Matos case says.
Yes, we think that that case is distinguishable on two bases. Number one, there was a continued course of conduct in Matos, I'm not sure how you pronounce it. So the individual actually went and met with the child. He could see the child with his own eyes, he could see that she was being exploited, and he kind of, on repeated occasions, he kind of wrapped himself up into that. He paid the money went to her handler, her pimp. So that is a different kind of class of cases because through a continued course of conduct, he engaged in human trafficking to the extent that he knew that the person was being trafficked. As opposed to here, and think about some of the text messages that were sent by my client. She said, what do you want to do? He said, we don't have to do anything if you don't want to. We don't have to do anything. We can just smoke some weed and chill. So that's not the conduct that is indicative of trafficking that person. So again, as we say in the brief...
Bring $150 just to smoke weed and chill?
Look, I think that if it's traveling to meet a minor, the evidence was sufficient at trial to prove that. But again, we're dealing with trafficking here. And so if they wanted to write a freestanding prohibition against prostitution, which is already on the books, but if they wanted to include, that legislatures don't hide elephants in mouse holes, right? So if they wanted to make simple solicitation of prostitution the subject to these draconian penalties, and again, we know from Dubin that you look to the actual penalties that are at issue as context clues as to whether or not the conduct that's prescribed by the statute meets the conduct that has been proven at trial.
Well, this isn't even subject to the solicitation of prostitution because it's a minor.
Right.
Explicitly, that doesn't apply. So that's not what's at issue here. But was this argument that you're making now, was this argument made to the trial court?
The argument that I'm making now is, I think it was fairly preserved, Your Honor. Here's what he said. Counsel said, Judge, I just don't see the human trafficking that was there. The guy's being told to show up at a certain location. He showed, he eventually shows up, but absolutely makes no act at that point to try to meet anybody. And then the state goes on in response, and this is, again, the whole point of preservation is to put the court on notice as to what the basis of the argument is. And so the state kind of provides additional context. Here's what the state says. As for the human trafficking, there needs to be either the actual or attempted act of commercial sexual activity with the person believed to be the child. By the person believed by the defendant to be the child. Here we have testimony by numerous people saying that there were those text messages. He agreed to the $150 to engage in sexual activity with the person he believed was a child. So we do believe that human trafficking should go to the jury. So based on all that, the state is saying it's enough that he showed up and he wanted to pay money for a commercial sex act. That's enough to bring it within the ambit of the statute. And we think that reading is wildly overbroad. It would sweep in, there's nothing in the text of the statute, the definition of human trafficking, it makes no distinction by virtue of age. So
but that argument that now you're making today, that you just continued on from the state, none of that was argued to the trial judge. It was basically, they didn't meet the elements because there's absolutely no act at that point to try to meet anybody.
We're arguing that there's no trafficking.
Right, and then the state's saying, no, these are the elements and this is what we've shown, which is a JOA argument, and now the end, and now you're making, again, the argument that you're making here today. But that argument that you just restated, you were not continuing on in the transcript, correct?
Yeah, no.
That was an argument you're making here. I just want to make sure that I understand.
Yes, okay. Your Honor. That is the argument that we're making here in a nutshell is that there was no trafficking. That's what the argument that counsel said. I don't see human trafficking. There's no trafficking here. That's the argument that counsel advanced.
No, you're making the argument that it's technically there, but it doesn't fit. You're making the fish argument. You're saying it fits the elements, but it shouldn't fit the elements because it's a different kind, character, et cetera. That is, I just want to, again, I'm just trying to understand because that is a different argument.
We think it's boiled down to its essence. There is no trafficking here. That's our argument. That's the argument that was made in the trial court, and that's the argument we're advancing. Of course, even if the argument has been developed more robustly here in the briefing and in the argument before the court here today, even if the argument has shifted slightly, I still think that if the person has not committed the crime that was charged, you have an affirmative obligation to say that, wait a second, this is fundamental error. The statute doesn't meet these facts. Line prosecutors don't charge human trafficking in cases of simple prostitution. It's just not what the statute was meant to cover. And so if you agree with our argument, then don't decide it on preservation grounds. Decide it on the fact that he hasn't committed the crime that was covered by this statute. So we think either way, and you know what, if I didn't preserve it as an appellate attorney or trial counsel didn't preserve it as a trial counsel, it's still going to come back up in a 3.850 motion. So decide it now or decide it later, it's up to you. I would urge the court to decide it here and now today, and if we're wrong, explain why we're wrong in a written opinion, and perhaps we can seek either petition for writ of certiorari in the United States Supreme Court, or we can seek conflict. Well, there is no conflict, I don't guess, because it's just Matos, but we would like to seek further review in the Florida Supreme Court because we don't think that this conduct is covered by this particular statute. And even if the literal terms of the definition of human trafficking, again, we're not conceding that these could cover it because of the reasons in Yates and in Dubin. We don't think that it covers it because you don't look in like Amelia Bedelia fashion to the broadest possible way that a statute could be read. You have to kind of, like they did in Yates, kind of restrict your analysis to what the statute is meant to address. But even if the statute could cover it, then we're into due process problems because a prosecutor can take, a statute, a second-degree misdemeanor in soliciting prostitution and charge it as a first-degree felony under the statute on the whim or caprice, or maybe the prosecutor's having a bad day. I mean, there are serious due process problems with that formulation, and we would hope that the court would take that into consideration. So there's the due process problems over here with regard to the void for vagueness doctrine. We also have due process problems with respect to the vindictive prosecution. And you know what? I mean, it couldn't be more clear from the record. He was given an ultimatum. You either forfeit your rights to a trial by jury, or else we're going to charge you with a life felony, even though we could live with an 8-year sentence. We're fine. We offer you 8 years. That's fine. But if you don't, submit to our will here and take this plea deal today, we're putting it on record. We're going to charge you with the life felony. And so I don't think that there could be any clearer. My friend on the other side, he makes the point, well, we could have charged it that way at first. Well, the difference does make a difference, or the distinction there does make a difference, because when you put it on the record, the reason why we're charging you with the life felony is because you're refusing to accept a plea. I mean, they said the quiet part out loud there. That is vindictiveness. There is a due process problem there. There's a due process problem with the void for vagueness issue, and this court can sidestep those due process problems by simply taking the most natural reading of the statute, and like it says in the first paragraph, the legislature finds that victims of human trafficking are subjected to force, fraud, or coercion. We're just asking the court to read that language and import it into the provision of human trafficking where it says, for the exploitation of the person. So exploiting by way of force, fraud, or coercion. So in the same way that like Staples and some of these Supreme Court cases where they sidestep due process problems, by narrowing the definition that's at issue and kind of including the mens rea component to it, meaning that you intended to use force, fraud, or coercion for the purposes of trafficking this individual. Your Honors, there's no trafficking here. I'll reserve the remainder of my time.
Right,
Thank
sir.
you.
Thank you very much. Mr. Bradford.
Good morning, Your Honors. My name is Robert Bradford. I represent the state of Florida in this matter. I just wanted to start with vindictiveness briefly. The McClover case, which talks about the test for vindictiveness, cites U.S. v. Goodwin, in which the evolution of this line of law is traced all the way up to the Hayes case, in which the United States Supreme Court said almost 50 years ago that a prosecutor can come back and use an HFO sentencing enhancement after that defendant has declined its plea offer. Basically what the Hayes court said was that a prosecutor can use whatever leverage he has, period. It doesn't matter what chronology it comes in. It's simply they have the leverage. If they can use it, they can use it, period, end of story. With respect to issues 1 and 3, I think they're enough related. I'd just like to address them briefly together. I'll start with the Yates and the Dubin case. Neither case has anything to do with this, and there are several reasons why. First of all, they both involve statutory interpretation of federal statutes not using the Constitution, so therefore it's a complete matter within federal law and has no bearing on state law. Mr. Ford was prosecuted under a criminal offense in the state of Florida. Another reason is under the Machutka case, and I apologize for my pronunciation there. The Florida legislature, absent any constitutional infringement, has the power and the right to define state of criminal offenses in any manner it sees fit. It also has the manner to prescribe the punishment for those offenses, again, absent any constitutional infringements, in any manner it sees fit. There is no constitutional issue with this. This is a complete matter of the Florida legislature defining human trafficking to include an adult using or trying to use a child prostitute. They had the right to do that, and more specifically, Yates and Dubin have to deal with the use of generic words to prosecute in a manner not contemplated by the statute or by Congress in that particular case. In this case, that is exactly what is contemplated by the Florida legislature when they enacted this statute, because that's how they defined it. They specifically and expressly in the statute included an adult who tries to use a child prostitute as a human trafficker. That the appellant doesn't want to recognize his role in this industry by twisting the words of the legislature is of no moment. We can talk about which came first, the chicken or the egg. I mean, is the supply side there because did they create the industry, or did the demand create it? Generally, the demand creates industry, just a normal business principle. So therefore, when the legislature decided to combat this industry on both ends, it had every right to do so. The analogy to drug trafficking, I think, bears into that same argument in the sense that the Florida legislature chose not to include street-level, small-amount buyers of narcotics in the trafficking statute. But as I think the court pointed out, even if a regular buyer, just a consumer of drugs, buying for his own personal use, let's say, if he is buying an amount defined as trafficking under the statute, he is a trafficker, period, end of story. My friend raised an issue of possible fear of a due process violation when prosecutors prosecute the buyers of prostitutes as human traffickers. First of all, that entire argument is pretty much a red herring because, first of all, there's no right to hire a prostitute in the state of Florida. And secondly, and we'll set aside for the moment whether an adult prostitute ever actually voluntarily consents, even if she's being paid. But in this particular case, the human trafficking statute does not make the solicitation of the hiring of an adult prostitute by an adult without more. It's not trafficking. There's a whole laundry list of things, and the state has to prove additional facts for each one of those And none of them, under no circumstances, can the state of Florida charge somebody with human trafficking when they purchased or tried to purchase an adult prostitute without more facts. The buyer has to use coercion, there has to be transport, they have to bring them in from out of state, something along those lines. There has to be just more facts that we'd approve. And I'll finish up because I honestly, I think everything here has been covered. With respect to the JOA argument and then the first issue, I do think it's a preservation issue that should control the day. Under the Murray case cited by appellant in the reply brief, while I agree that there are no magic words, in that particular case, the trial counsel had sufficiently specified to the court what issue they were going on, and they challenged, I think he specifically said DNA, there was nothing linking that defendant to the scene, and so he was arguing identity of the defendant, and he just never said identity, and the court said, no, it's close enough, he got close enough. The court below knew what he was talking about. In this particular case, I don't see human trafficking can in no reasonable way be interpreted to mean there's no human and there's no force, fraud, or coercion. So neither one of those arguments is preserved. And specifically under the Rodriguez case, also cited by the defense, by appellant. In Rodriguez, that was a JOA case, and the Rodriguez court held that to preserve a JOA argument, you have to specifically identify the particular element that you're challenging, that you're saying the state did not prove or did not satisfy. And that simply was not done here. So, and as far as the vagueness argument, it was also not raised at trial. At trial, the only constitutional argument was that the lack of a human constituted cruel and unusual punishment. So that wasn't preserved either. But strictly, and with due respect to opposing counsel, the void for vagueness argument, he writes it down in a as applied scenario. It's really not, because the argument he makes that it doesn't tell people who hire prostitutes that they're human traffickers. First of all, that's not the facts of this case, and secondly, it's more of a on its face argument because it applies to everybody, not just him. As applied would be to him, and to him would be child prostitutes, and of course that argument doesn't work because that's how the legislature chose to define it. So, unless the court has any questions for me, I will rely on my brief for any additional argument and issues and ask the court to affirm the judgment and conviction in all respects.
Thank you, sir. Mr. Greenlee, you have just over 5 minutes.
Thank you, Your Honor. Briefly on the vindictive prosecution argument, the case my friend was citing to, of course, if somebody is already subject to a HFO as a habitual felony offender, yes, you know, that he is subject to that. There's no dispute about that. We do dispute that my client was subject to human trafficking. The notion that you can use any leverage however you want to use it, not true. If you have vindictive intent, if you're actually acting with actual vindictive intent, that's unconstitutional. That's a due process problem. With respect to the statutory interpretation, of course, Yates and Dubin, they don't relate specifically to human trafficking, but the principles articulated are applicable here. Yates, it was a record-keeping case. So we're not going to have a fish that's a tangible object. Yes, it meets the actual definition set forth in the statute. My friend says that, you know, the Florida legislature can write whatever it wants in a statute. Fair enough. But we're here to determine what the scope of that criminal statute, what conduct is covered under that criminal statute. And so as a matter of statutory interpretation, we do look to the context. Not the nascitura associus principle kind of directs us to look at what's covered. What is the purpose of the statute? In Yates, it was record keeping. In Dubin, it was aggravated identity theft. Here, it's human trafficking. Again, slavery, enslaving individuals, not consensual prostitution. I heard my friend say that demand, well, the statute seeks to get at demand? Well, if that's the case, then ordinary prostitution covering, why could they not subject adults to that? If you look at the definition of the statute, there's nothing that would prevent an adult being charged. The statute says it does apply to adults. In the first paragraph of the statute, it says it applies to adults. So there's no, there's no real reason why you couldn't charge simple solicitation of a prostitute between two consenting adults. Now, I take my friend's point that maybe a prostitute can consent, maybe a prostitute can't consent. But I could conceive of circumstances where a prostitute is consenting, the person who's procuring the services is consenting as well. Are we going to call that human trafficking? I think not. I don't think anybody in this courtroom would say that's human trafficking. My friend says, well, why can't you charge that? He says, well, there's other things in the case of an adult that you have to prove. I think he said coercion is one of them. Well, it sounds like we agree. If coercion is at the heart of this statute, force, fraud, or coercion, like I'm advocating for, then you would have to prove that somebody intended that force, fraud, or coercion be used. And there was no evidence of that. No evidence at any point in the trial. So, as much as my friend would like to say that the statute wouldn't apply in instances of ordinary, prostitution between adults, nothing in the statute prohibits it, and that is kind of the crux of our due process void for vagueness problem. The prosecutor, if they're having a bad day, if they don't like the way somebody looks on a particular day, somebody wears their hair long instead of short, you can charge them with human trafficking when all they've done is engage the services of the prostitute. So there are due process problems there, both on the vindictive prosecution side as well as on the void for vagueness side. And it is as applied to my client because the facts of this case are 10,000 miles away from human trafficking. He's not trafficking anybody in the ordinary sense that we use the word trafficking. He just showed up at a location. If there are no further questions from the court, I've said all that I came to say. Thank you, Your Honors.
All right, sir, thank you very much. Gentlemen, we appreciate well-prepared, well-presented arguments. And with that conclusion, we will stand in recess.
Is that just going back in the library? Yeah. Where the office is in the corner? Yeah. I don't think I need to do after inspection.